state officers, whereas Section 30 of the County Government Act 2012 provides for the functions of the governor, whereas Section 45 of the Anti-Corruption and Economic Crimes Act of 2003 provides for protection of public property and revenue, whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. 1. In a letter dated 18th January 2021, the County Secretary communicated the decision of the County Executive, an organ presided over by His Excellency Amos Kimomi Nyaribo, to the County Public Service Board, seeking the secondment of 2 cherry-picked officers, Godfrey Kiriago Nyangao and Elmelda Nyaberi, to the positions of Director Human Resource and Payroll Management, respectively. In response, the chairperson of the County Public Service Board wrote back to the County Secretary demanding that the said offices ought to be vacant and that the process must follow the laid down procedures and legal provisions. 2. The governor influenced the transfer of substantive office holders to create room for the cherry-picked officers and caused irregular integration into the county payroll. 3. By initiating the non-competitive appointment and retention of the cherry-picked officers, the governor violated the principle of meritocracy and demonstrated a profound abuse of his office, leading to a direct and quantifiable loss of public funds, since the 2 officers were hitherto substantively occupied. 4. The governor further influenced the appointment of Godfrey Kiriago to the position of Deputy County Secretary and influenced the renewal of Mrs. Elmelda Nyaberi's contract post her retirement date. Allegation number 3. Abuse of office through personal enrichment from receipt of irregular salary arrears of Kenya shilling 5,649,706. Whereas Article 201A, D, and E of the Constitution of Kenya state as follows: B. There shall be openness and accountability, including public participation in financial matters. F. Public money shall be used in a prudent and responsible way. G. Financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 234A of the Constitution of Kenya 2010 mandates the Salaries and Remuneration Commission (SRC) to set and regularly review the remuneration and benefits of all state officers. Whereas Section 97 of the Public Finance Management Act 2012, PFM Act, requires public funds to be used in accordance with the law and for the purpose of which they were appropriated. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. 1. In September 2021, through the facilitation of the 2 cherry-picked officers, Mr. Godfrey Kiriago, Director Human Resource, and Elmelda Nyaberi, Payroll Manager, the governor conferred upon himself an irregular salary payment christened as arrears amounting to Kenya shilling 5,649,706. It is apparent that there was no outstanding arrears due to the governor since his assumption to office, and neither was he owed any arrears as deputy governor. 2. The governor's self-authorized receipt of Kenya shilling 5,649,706 in salary arrears outside the Salaries and Remuneration Commission guidelines is a clear act of personal enrichment, abuse of office, and a direct violation of PFM Act. 3. The governor has publicly confessed that he received the above irregular payment. The people of Nyamiraa lost services and development programs to the tune of Kenya shillings 5.6 million on account of his abuse of office and or his actions. Number 4, the governor has formed a habit of conferring upon himself irregular benefits going by other incidences. For instance, in the year 2019, the governor caused to be paid a retrospective compensation of Kenya shilling 13 million in allowances for housing, bracket, a benefit, not an allowance, and made a double medical claim in form of ex gratia, despite full settlement of his medical bills by the defunct NHIF, all outside of SRC guidelines, which clearly demonstrate a pattern of personal enrichment, abuse of office, and direct violation of PFM Act. 5. This direct financial benefit to the governor constitutes a direct loss of public funds and demonstrates a clear case of personal enrichment through corrupt practices and abuse of office. Allegation number 4, abuse of an ECD teacher, bracket Kenya shillings 25,018,852. Ms. Gladys Mora Nyambane, an ECDE teacher, bracket Kenya shilling 1,100,467. And Mr. Isaac Kerongo Onchiri, an ECD teacher, Kenya shilling 700,836. 2. While under oath during his appearance before the Senate's Public Accounts Committee, the governor admitted to have received the illegal benefit. Allegation number 5, abuse of office by influencing dual appointments outside the lawful establishment. Whereas Article 235 of the Constitution of Kenya 2010 states that a county government is responsible within a framework of uniform norms and standards prescribed by an Act of Parliament for A, establishing and abolishing officers in its public service, B, appointing persons to hold or act in those offices and confirming appointments, and C, exercising disciplinary control over and removing persons holding or acting in those offices. Whereas Section 51 of the County Governments Act 2012 provides that there shall be established at the level of each sub-county the office of sub-county administrator, and whereas Section 51(1) of the County Governments Act 2012 provides that there is established for each ward in a county the office of the ward administrator. Further, whereas these offices were already substantively filled in the year 2014, upon assumption of office in 2021, the Governor, Honorable Amos K. Nyaribo, aware that these offices were substantively filled, deliberately allowed the recruitment of sub-county and ward administrators to fill the artificial vacancies, leading to double appointments and hence double payment of salaries, depriving the county of development funds. Whereas Section 10(5) of the Employment Act 2007 provides for the procedure of change of contract terms for an employee, the Governor, through letter reference NCG/TRNSF/TRNSF/VOL/3/283 dated 27th June 2024, redeployed 10 officers, bracket ward and sub-county administrators, to positions in which they had no requisite competencies, so as to create room for the dual appointments. Allegation number 6, abuse of office through usurpation of powers of the Auditor General and the County Public Service Board, and violation of due process through illegal payroll, audit, and demotions. Whereas Article 47 of the Constitution and the Fair Administrative Action Act 2015 enshrine the right to fair administrative action and due process, whereas Article 229 4A4 provides that within 6 months after the end of each financial year, the Auditor General shall audit and report in respect of that financial year the accounts of the national and county governments, whereas Section 59A of the County Governments Act 2012 provides that the county public service shall A, be independent and shall not be subject to the direction or control of any other person or authority, and whereas Section 59F and Section 61G of the County Governments Act 2012 vest the power to exercise the disciplinary control over and to remove persons holding in the county public service squarely in the County Public Service Board, whereas Section 35 of the Audit Act 2015 provides for the procedure and manner of auditing public entities. 1. In September 2021, the governor purported to demote more than 100 staff, which action was reversed by the Employment and Labor Relations Court sitting in Kisumu. 2. Further, in May/June 2024, he demoted another 254 staff on the basis of a payroll audit report without the process, usurping the function that falls squarely under the purview of the County Public Service Board. 3. The governor appointed a payroll audit team without due regard to Section 35 of the Audit Act, approval by the County Assembly or the Auditor General, contrary to legal requirement. 4. Human resource payroll relates to use public funds and can only be audited as envisaged by Article 229 of the Constitution. 5. The Auditor General is the only constitutionally mandated body to audit all state organs, including county governments, and it has not delegated any of her mandates to any institution to carry Nyamiraa county payroll audit. 6. The action of the governor to carry county payroll audit without proper authorization or delegation is a straight usurpation of the constitutional mandate of the Auditor General, and therefore in violation of Article 229 of the Constitution of Kenya 2010. 7. Article 226(3) of the Constitution states that the accounts of all governments and state organs shall be audited by the Auditor General. The action of the governor to carry out county payroll audit without proper authorization of the Office of the Auditor General is in contravention of the Constitution. 8. Article 229(1) of the Constitution creates the independent office of the Auditor General, and Article 229(4) of the Constitution cuts what the auditor ought to undertake. The action of the governor to carry county payroll audit without proper authorization of the Office of the Auditor General and without the knowledge of the office undermines the independence of a constitutional office and is in contravention of the Constitution. 9. Article 229(5) of the Constitution states that the Auditor General has the liberty to audit and report on the accounts of any entity that is funded from public funds. Section 34 of the Public Audit Act 2015 provides for periodic audits to be undertaken by the Auditor General at his or her own initiative or upon request by an entity. The Auditor General has audited Nyamiraa County. There are audit reports, and there is no explanation whether the county government found existing audit report inadequate. The governor have not requested the Auditor General to carry out any audit. The governor have not requested for the County Assembly of Nyamiraa to sanction the Auditor General to undertake any audit. 10. Section 23 of the Public Audit Act 2015 provides for outsourcing of audit services, while Section 24 of the Public Audit Act 2015 provides for engagement of services of technical experts or consultants and professionals in fulfillment of Article 2296 of the Constitution, which states the principal purpose of the audit is to confirm whether or not public money has been applied lawfully and in an effective way. The Auditor General did not establish the firm that did the county payroll audit. 11. An audit is a process that follows cardinal guidelines which the purported auditors of the county executive payroll did not follow before coming up with a purported payroll audit report. Section 31 of the Public Audit Act 2015 provides how the process of the audit shall be undertaken. 12. Section 36 of the Public Audit Act 2015 provides that the audit report is submitted to Parliament or County Assembly for tabling and debate. How the county payroll audit report, which was not done by or authorized by Auditor General, will be placed to Parliament or the County Assembly for debate and consideration has not explained. 13. Section 37 of the Public Audit Act 2015 provides for the forensic audits upon request by Parliament or County Assemblies to establish fraud, corruption, or financial improprieties in state organs and public entities. The audit report is then placed to Parliament or the County Assembly for debate and consideration where appropriate resolutions and actions to be taken emanate. 14. The Governor therefore usurped the constitutional mandate of the Auditor General, which he arrogated himself to initiate payroll audit without authorization. 15. The County Public Service Board, in their submissions in county appeals matter before the Public Service Commission through the respondent's reply to appeal in paragraphs 12, 13, and 20, affirmed that the Governor singularly commissioned the payroll audit, including appointment of an ad hoc committee that will digest the findings of the audit. 16. The County Public Service Board, CPSB, in a communication dated 15 January 2025, reversed the Governor's purported demotions, explicitly implying that the demotions were processed without the board's involvement or approval, confirming the usurpation of the board's mandate. 17. The County Executive Committee, sitting in September 2025, resolved that it was aggrieved by the CPSB's reversal and will be appealing against this decision, fully aware that it has no provision for appealing. An advisory from the county attorney affirmed this is an advisory to the Chief Officer, Public Service Management. This further demonstrates a governor that is hell-bent in usurping the role of the CPSB. 18. The governor's actions bypassed the established legal framework for personnel management, denying the affected staff due process and leading to demoralization and disruption of service delivery. 19. The governor's decision to personally initiate and execute disciplinary action (demotions) based on an irregular audit without reference to constitutionally mandated CPSB or following due process is a clear and unconstitutional usurpation of power and violation of staff members' fundamental rights. 20. The governor's intention to appeal the decision of the CPSB was in any case an act in futility, as the decisions of the County Public Service Board are deemed to be made for and on behalf of the county government. 21. Additionally, the County Assembly, while considering a report of the Sectoral Committee on Public Service Management on staff progression, passed resolutions that included, among others, 1. The reinstatement of demoted officers to their rightful job groups and payment of their full emoluments. 2. The censure of the Chief Officer, Public Service Management, Mrs. Rael Omanyi, and the further resolution to have her step aside for contempt of the County Assembly and its committees. 22. The Governor has to date failed to enforce resolution number 2 above, and equally failed to implement the resolutions of the County Assembly in this report. Allegation number 7. Abuse of office by purporting to suspend the Secretary to County Public Service Board. Whereas Section 58(5)(b) of the County Governments Act 2012, as read together with Article 2511 of the Constitution of Kenya 2010, provides that the members of the board may only be removed from office by a vote not less than 75% of all the members of the County Assembly. 1. The above article and/or section do not anticipate or confer power upon the Governor to cause such an action as suspension of a Secretary to the County Public Service Board. 2. His Excellency Amos Kimwomi Nyaribo acted ultra-vires by purporting to suspend the Secretary to the County Public Service Board by the letter reference NCG/GVN/VOL.1 dated 2nd May 2023 beyond his powers as provided for in Section 31 of the County Governments Act 2012.
You may proceed, Clerk.
Honorable Amos Kimwomi Nyaribo, how do you plead to the two grounds, guilty or not guilty? Ground 1.
Not guilty.
Ground 2.
Not guilty.
Now, the plea having been taken, we will move to hear opening statements from both teams unless the preliminary matters that the parties would wish to raise. If there are no preliminary matters, we shall move to opening statements, starting with the County Assembly. Yes, Counsel for Governor.
Thank you, Mr. Speaker, sir, and honorable distinguished senators. My name is Elias Mutuma, representing the Governor in this matter. Mr. Speaker, sir, you will recall that on 1st of December, we did formally raise a preliminary objection dated 29th of November 2025, which is seeking to have the proceedings before the Senate terminated in a summary manner before proceeding for full trial. Mr. Speaker, sir, I will be arguing this main PO with your leave, and my learned friend, Mr. Atemo, will also raise 2 applications at the end of my presentation. Honorable Senators, the preliminary objection before you is the one dated 29th November 2025.
So, Counsel for Governor.
Yes, sir, Mr. Speaker, sir.
You were to indicate that you're going to raise a preliminary objection so that I give time indication.
Most obliged. Thank you.
Now, if you look at the rule, at Rule 14 of the Rules of Procedure in schedule, in the 3rd schedule, we have 30 minutes to conclude matters of a preliminary nature. I will therefore give you 20 minutes to argue your preliminary objection. I will give the County Assembly 20 minutes to respond and 5 minutes to make your rebuttal, so that we then, the Senate can deal with that. You may now proceed.
Thank you for that guidance, sir, Mr. Speaker, sir. And my
Your
apologies.
time starts running from now.
Thank you. Thank you, Mr. Speaker, sir, for the opportunity. Like indicated earlier, we have raised a PO, the one dated 29th of November 2025, and contains in the Governor's documents at Volume 1. It's a very thin document, volume 1 of the governor's documents. A very thin document, Mr. Speaker, sir. Mr. Speaker, sir, the objection that we have raised through this PO is not just about a procedural issue. It boils down to the very core and principles of our Constitution, because the motion that has been presented before you and the resolutions by the County Assembly of Nyamiraa do not meet the legal threshold. At the end of my presentation, honorable senators,